CSR non-compliance cost 20 lakhs. This is a NTL India Limited compounding order companies under Companies Act 2013. So welcome back to the channel. Today we are discussing an important compounding order passed by Regional Director Southern Region Chennai involving NTL Limited, where violations relating to the CSR corporate social responsibility provisions resulted in compounding amount of 20 lakh rupees. The case highlights that failure to constitute CSR committee, failure to formulate a CSR policy, and failure to make CSR disclosures and spend the prescribed CSR amount. So these attract serious consequences under the Companies Act 2013. So let us understand the legal provisions and what are the violations and what are the arguments made by the company and the final order. An application for compounding of offence was filed before the RD, Southern Region Chennai, under Section 441 of Companies Act 2013 by NTL Limited, Managing Director, Full-Time Director and Former Director. Application sought compounding of offence relating to Section 134.3.0, Section 135 subsection 1, Section 135 subsection 3, Section 135 subsection 5 of Companies Act 2013. So understanding CSR under CSR Companies Act 2013. So before discussing the violations, then let us understand the exact CSR framework. So what is CSR? CSR is a statutory obligation. Corporate social responsibility is a corporate obligation imposed on the eligible companies to contribute towards social welfare and suitable development CSR activities. So example, education, healthcare, rural development, environmental sustainability, skill development, women empowerment, disaster relief. So these few of these activities under Schedule 7. So to schedule the activities listed under Schedule 7 of Companies Act 2013. So Section 135 subsection 1 Constitution of CSR Committee applicability. So under Section 131, every company meeting specified financial thresholds must constitute CSR Committee of the board. And the CSR applicability criteria: net worth of 500 crores or more, turnover of 1000 crores or more, net profit 5 crores or more. So during immediately preceding financial year, these are the limits need to be checked. Such companies are required to constitute CSR committee constituting 3 or more directors. So as per the applicability, Section 135 subsection 3 functions of CSR committee. CSR committee has a crucial responsibilities. Example like a formulation of CSR policy. Committee must formulate and recommend CSR policy to the board, indicating the CSR activities to be undertaken. And the recommendation of expenditure. The committee must recommend the amount of CSR expenditure to be incurred. Monitoring CSR policy. The committee is required to monitor implementation of CSR activities and CSR policy from time to time. If you see 135 subsection 5, there is a mandatory spending. The board must ensure that company spends at least 2% of average net profits of the preceding 3 financial years on CSR activities. Section 134 O CSR disclosure in board's report. Apart from spending obligation, disclosure requirements are equally important. Section 134 subsection 3 clause 4 requires the board's report to contain details. Details like CSR policy, CSR initiatives, CSR implementation, CSR expenditure. So these are all taken during the year. Failure to make these disclosures constitutes violation of law. So the violations committed by NTL India Limited, according to the application filed before the RD, the company committed violations of 135 subsection 1. What is that? Failure to relating constitution of CSR committee. Another violation 135.3, failure in CSR policy formulation and monitoring mechanism. 135 subsection 5, failure relating to CSR expenditure obligations. And 134.3.0, These 134.30 failure to provide prescribed CSR disclosures in the board's report. So these violations pertain to multiple financial years, 2015-16 to 19-20. So the penalty provisions applicable order specifically refer to section 134 subsection 8. Under the provision, company fine ranging from minimum 50,000 to maximum 25 lakh. So what happened here? The contravention 134. Here the role of ROC, the Register of Companies Chennai, examined the matter and reported that the company filed a Form GNL1 seeking compounding. It was first offence, no prosecution had been launched. ROC had no objection to compounding of the violation. So this demonstrates that importance of voluntary compliance and proactive rectification, because the company filed voluntarily went for compounding. So here the company's defense is, during the hearing, the authorized representative submitted that violation was unintentional, and the company stated that non-compliance was not deliberate or willful, and also said procedural oversight. According to the company, the lapses occurred due to procedural deficiencies in CSR compliance and also first-time default. Company emphasized that this was its first offense. Also mentioned COVID-19 impact. So the company also referred practical challenges arising during the pandemic period, including unavailability of professional consultants and compliance difficulties. Company requested RD to take a lenient view. RD findings are company submission, ROC report, nature of violations, and facts of the case. RD decided to compound the offence under section 134.30, 135 subsection 135 of the Companies Act 2013, and RD imposed the compounding fee. We can see compounding fee NTL India 5 lakh rupee, and the MD another 5 lakh rupee, full-time director 5 lakh, another ex-director 5 lakh. Here we can see total 20 lakh. So this is a compounding fee. Directors can also held personally liable. This is what we can see. CSR is not an optional. Board responsibility is a critical. So the board must ensure CSR committee constitution, policy formulation, spending, reporting, because the personal liability also is there. Disclosure failure also serious. Even if some CSR activities are undertaken, failure to properly disclose them in the board's report may attract penal consequences. So every CSR applicable company should ensure CSR applicability reviewed annually, and CSR committee properly constituted, CSR policy approved by the board, CSR objects mapped in Schedule 7, 2% CSR spending monitored, unspent CSR amount handled as per the law, CSR disclosures included in the board report, website disclosures updation, CSR committee meetings. So these are all the things has to be taken care by the board. We have two channels, RR Corporates and other channel, RR Legal Talks. Please do subscribe and hit the bell icon so that you will not miss my latest videos. Thank you.